Greetings, Carl Groves with Disability Consulting here. I want to talk to you today about your hearing. So, in the disability process, if you've gotten denied at the initial level and you or your representative have appealed to a reconsideration, and it goes there, and that claim also gets denied, and you appeal, that appeal is for a hearing before an administrative law judge. The way you do that is usually online. It's very, I'm not gonna say it's easy, but it's pretty straightforward on the way that a disability hearing appeal is made. So the big question that you're probably wondering is, at the initial level, at the reconsideration level, the disability determination section, the people who denied me twice, they had all my medical records. They had all these forms that I filled out. Why do I have to go to a hearing if the judge has all those records and has all those forms? That's a great question, and that's what I want to talk to you about today. So even though the medical records are probably in your file, the forms that you filled out talking about your pain, talking about what you can do during the day, talking about the jobs that you had in the last several years, all those are in the file. You probably have not talked to a decision maker about your conditions. And so I want to talk to you, first of all, about why you're there. You're there to talk about your symptoms. When I'm prepping my clients, and we'll talk a little bit about what that means, but when I am prepping my clients for a hearing, I tell them, if you don't remember anything else that I tell you here, usually a week before the hearing, remember that we're there to talk about your symptoms. It doesn't matter that you have degenerative disc disease. It doesn't matter that you have diabetes. It doesn't matter that you have bipolar. What does matter is, do you have difficulty standing, walking, lifting, carrying, concentrating, getting along with other people? You have problems with fatigue. You have to take naps. Those are the things that we're there to talk about. And believe it or not, when they're not in a form, asking you about household chores and feeding your pets and walking to the mailbox, when you're actually talking about those things, the judge can actually better determine your credibility. Is Mr. Smith telling me the truth right now? He really sounds like he is, and his discussion of his impairments is pretty convincing. So the reason for the hearing is you actually get to talk to somebody about what's going on with your life, and it's no accident, at least to me. I've been doing this been in disability for 34 years now. I've been having my own practice since for 21 years of that. And it's no coincidence that a disability hearing where you get to actually tell somebody what's going on with you, you're not filling out forms, you're actually testifying. It's no coincidence that this is the hearings level is your best level to get approved. So, who all is in a disability hearing? We talked about what you're there for, talk about your symptoms, but who all is in a disability hearing? Well, obviously you're going to be there. Your representative is going to be there. The judge is going to be there. A court reporter is probably the one who's going to contact you and get everything set up. And then there's a vocational witness, and I want to talk about each of those people. First of all, you know who you are, so I'm not going to talk too much about you. Your representative is there to either cross-examine you and or cross-examine the vocational witness. The judge is there to make a decision. The judge will ask some questions. The judge will conduct the hearing. He'll swear you in. Even though a hearing is quite informal, you are given sworn testimony, so the judge is going to swear you in, and he'll also swear in the vocational witness. And the vocational witness is that odd man out. The clerk, I don't really need to talk to you about what the clerk's there for. They're just there to record the hearing. They don't say hardly anything after, Your Honor, everybody's present, and they hit the record button and the hearing proceeds. But the vocational witness, that's the odd man out. A lot of my clients get hung up on this. Okay, Carl, you're there to represent me, correct? Absolutely correct. That is my job. Who's against you? In a court of law, if there's a plaintiff, there's, somebody against them. If there's a defense, attorney, there's a prosecutor. In a disability hearing, there's nobody against me. There's nobody advocating against disability. I'm advocating for disability. I believe that you're disabled and this is why. There's nobody that's going to say, well, you're not disabled, and they pound a table and all sorts of garbage like that goes on. It doesn't go on in disability hearing. They're very orderly. They're very calm. A lot of my clients tell me that they're very boring. It's just a conversation. Well, you want boring and you want them to be very conversational. But there is a trade-off. Because there's nobody against me and you, there's nobody against us in a disability hearing, the burden of proof to prove that you're disabled is 100% on us. We have to prove your case. And the way we do that is with your medical records and with your testimony. So what exactly then does this vocational witness do? They're not a good guy. They're not a bad guy. They're not against me. The judge isn't against me. The vocational witness is there to talk about jobs. They have expertise in some numbers, the actual Dictionary of Occupational Title numbers. It's a 9-digit number that every job in America has. And they talk about that, and the judge will ask them at the end of the hearing a series of hypothetical questions. The questions are about you, but for some reason the Social Security Administration says they can't ask about you. So they'll say, consider somebody Mr. Smith's age with Mr. Smith's education and Mr. Smith's work history, and this individual would be limited, and then they give some limitations. And the vocational witness would say, yeah, that person can perform jobs, and these are the jobs, these are their codes. Or they'll say, no, that person cannot perform those jobs, but could perform some other jobs. Or no, that person could not perform any work with those limitations. So I prepare for several questions to ask a vocational witness based on your case. My questions, I know, are always going to get the answer that I want, which is the answer that we always want. That person could not perform any competitive work. That's the answer that we want in a hearing. But the vocational witness, they're called in all adult hearings. If you have one, the judge isn't picking on you. In 21 years of having hearings, I think I've had 2 that didn't have a vocational witness, and that's because the judge wanted to allow the case. Like 5 minutes when we got in there, the judge just asked me, are you okay if we do this and this and this? And yeah, I'm okay with that, and the case was done. They didn't need any kind of vocational witness testimony. Okay, so I told you that the hearings are informal. But keep in mind that the testimony you give is sworn testimony. So the judge is going to expect you to tell the truth, as do I. I expect you to tell the truth. And the judge is going to expect that the answers you give him in a hearing correspond with the answers that you put on the forms that you filled out at the lower levels. And I bring this up because it can go very poorly for you if you get into a hearing and you say, I can't do anything during the day. I can barely get out of bed. And then he says, well, Mr. Smith, I see that, a couple of years ago when you first applied and they sent you this form, you said you were able to mow the lawn and that you were able to walk about 200 yards before you'd have to rest. And you're telling me today that you don't mow the lawn and that you can't walk more than a few steps. And the judge won't say this, but this is what he's going to be thinking. Were you telling the truth back then and lying now? Or were you lying back then and you're telling the truth now? You never want to get in that position. You want to make sure that your answers are consistent. And you and I will talk about that before the hearing, and I'm about to go over, the hearing prep with you in just a minute. But your testimony during the hearing is sworn testimony, and the judge expects you to tell him the truth. There are things in a disability hearing that you're not going to want to talk about. what comes to mind is some mental health disorders. If you have difficulties with, harming yourself, thinking about harming yourself, nobody wants to talk about that, but you have to in a hearing. You're there to give the judge the truth, even if it's no fun for you to talk about. There are some things that might be embarrassing to you. If you have some kind of gastrointestinal disorders, you have to be near a bathroom, or you have incontinence and you have to wear, protective garments. You don't want to talk about that. Nobody wants to talk about that. In a hearing, you have to. We're not there to make any kind of impression like you would be for making an application for a job, in a job interview. You're there to tell the judge the truth and what your life is like. And the judge better walk away from this hearing thinking that your life is not going well, that your disability prevents you from doing a lot of things. So you got to be honest, even if the honesty is going to be embarrassing or it may be hard for you to talk about. So I said earlier that we'll go over a lot of this in a prep. And this, in many ways, the video that we're making today, this is very much like a prep would be. But I need you to understand why you have to do certain things, why you have to say certain things, why you have to embarrass yourself when you don't want to talk about this. Well, the reason is that this is it. This is your only opportunity. You haven't been able to see somebody face-to-face at the initial level. You haven't been able to see somebody face-to-face at the reconsideration level. Here you are face-to-face or on the phone talking to somebody in a very conversational way for the first time, and it'll be your only time, because if we appeal this one, it goes to a place called the Appeals Council. They're not going to call you. They're not going to ask you for anything. They're just going to look at your file and they're going to make a paper review. This is your one opportunity in a conversational way, either by phone or in person, to talk to somebody who has the power to make the decision that we want them to make. So you got to be compelling. You have to be credible. The things you say have to match with what your medical records say. If your medical records don't mention anything about problems with your hand, please don't come into a hearing talking about carpal tunnel. If it's not in the case record, there's really no reason to bring it up in a hearing, because it's going to go nowhere. The judges have to make decisions based on the medical records. So in a prep, I'm going to prepare you for a hearing. I will normally call you within a week of the hearing. Sometimes it's a few days, sometimes it's a full week before the hearing. I don't like to call you and go over your hearing any longer than that, because you're going to forget a lot of the stuff that I say. Another reason that we're making this video, so you have some reference to come back to if you need to. But in the prep, I'm going to tell you a lot of the things that I told you today. I am going to remind you of the reason we're there, and that is to talk about your symptoms. I will tell you in the prep over and over again, we're there to talk about one thing: your symptoms. We're there to talk about symptoms. Symptoms, symptoms, symptoms. Doesn't matter that you have degenerative disc disease. Can you stand, walk, lift, and carry? Doesn't matter that you're bipolar with horrible manic episodes. Are you able to concentrate? Are you able to stay on task? Are you able to get along with other people? Are you able to adapt to changes? Doesn't matter that you have chronic fatigue syndrome. It does matter if you have to take naps, 2 or 3 naps a day, and they last for an hour each. Okay, those are symptoms. And if you are wondering why they're important, symptoms are what keep you from working. The diagnosis doesn't keep you from working. A lot of people with these diagnoses that I've just given are working right now. It's the symptoms which will win your case. So that's what you need to remember. I also, in a prep, will give you my one rule. I have one rule in a disability hearing, and it's for everybody that I represent. If I or the judge ask you how long you can do something, you got to tell me the truth, but you got to give it to me in minutes. If I ask you how long you can be on your feet before you have to sit down because the pain in your back is so bad, if the answer is an hour and a half, I don't want to hear an hour and a half. I want to hear 90 minutes. Give it to me in minutes. If it's 10 minutes, it's a great answer. If it's, 45 minutes, it's a great answer. If you tell me or you tell the judge that you can do anything, lift, carry, stand, walk, concentrate, and you can do it for 3 or 4 hours, I can guarantee you here in this video, and I will guarantee you a week before our hearing in our prep, we're going to lose. If you can do things for 3 or 4 hours at a time, stand, walk, lift, carry, concentrate, stay on task, if you can do those things for 3 or 4 hours, the judge won't say anything in the hearing, but in the decision, the denial that we get a few weeks later, he'll say, Mr. Smith testified that he can do this. I'm wondering why he's even applying for disability. Because if you can do things for hours at a time, my friend, you are not disabled. You're not disabled under the meaning of the Social Security Administration, under really any meaning, if you can do things for hours at a time. So in the hearing, I want to talk about the actual structure of the hearing. They're very orderly, and they all pretty much go the same way. Right now, since COVID, past 5 years or so, the vast majority of hearings are by phone. So what'll happen is they will call me, the clerk will call me first, and the clerk will say, I have Mr. Smith's number as blah, 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 blah. Is that the correct number? And I'll say, yeah, that's the right one. And then they'll call you. And then if they don't have the vocational witness, they'll call the vocational witness, and then they all put us into this conference call with the judge. The judge will say, well, let's go on the record, and the judge will tell you while we're there, why you were there. You disagreed with the lower level decisions. I'm not bound by those decisions. I'm not even influenced by those decisions. I'm here to make a new independent decision based on the evidence in the file and based on your testimony here today. And then he'll probably swear you in and swear the vocational witness in. And the first parts of the questions that you can expect in a hearing are identification questions, especially if we're by phone. What's your social security number? What's your date of birth? What's your mailing address? Who do you live with? The next series of questions are usually the work questions. When's the last time you worked? What were you doing? And they'll want you to describe your past job. How much were you lifting and carrying? How much did you have to be on your feet? Was it a job that you had to do a lot of concentrating, a lot of skilled types of tasks? They'll ask you about that because it's very important that the judge knows what kind of job you did, and whether you have the capacity to do that job still or you're not able to do your past job. We're not there to prove that you can't do your past job. We're there to prove you can't do any work. And the way we'll do that is by asking you questions about your symptoms. But they'll ask you about the jobs. The judge will ask you about the jobs. Then this is where there's a little bit of variation. Sometimes, or some judges will turn the questioning over to me. Mr. Groves, please ask Mr. Smith or whoever. Ask your client about his conditions. And I'll ask you questions about standing, walking, lifting, carrying. I'll ask you about durations. How long can you do something? And you better remember that one rule. How long can you stand? Minutes, give it to me in minutes. How long can you concentrate before you lose focus? Give it to me in minutes. Again, if you tell me that you can do things for hours at a time, we're going to lose. So, if it's an hour and a half, tell me 90 minutes. Just minutes sounds shorter than hours does. I'll ask you some questions about household chores. I'll start usually with the easiest, which is making your bed, just getting up and getting everything kind of looking decent on the bed. And I'll go through some other household chores, vacuuming, sweeping, dusting, doing dishes, all the way to the hardest inside chore, which is doing laundry. And laundry's the hardest inside because you got to be on your feet to do some of it. You have to lift some serious weight because a basket full of wet clothing that you're taking out of the washer and putting in the dryer usually has some weight to it. It is a multitask job. You have to stay on it. As anybody who's ever forgotten that they didn't take the load out of the washer and put it in the dryer, they go back 2 or 3 days later and the washer is stinking because the clothes have soured and you have to start all over. So I'll ask you about that. I'll usually ask, are you doing yard work? And then if your answers are no to most of these questions, it begs the next question, which is, well, if you're not doing these, who's doing them? And usually it'll be a friend or a spouse or a relative. Somebody comes over and does that, and that's fine. Or if you have adult age children or children that are big enough to do some of these chores, you could answer that. Those are all good answers. Let me tell you what a horrible answer is. Well, they just don't get done. Nothing gets done. It's a terrible answer. The judge is not going to find that credible. Somebody who doesn't do any household chores and then says that the chores don't ever get done. So dishes are just piling up forever. Laundry is never getting done. It doesn't make any sense. Even my clients who are in wheelchairs are able to do things. So it's a bad answer to say that I do nothing. I can't do anything. You might not be able to do it well, and you might not be able to do it quickly, and you might not be able to do it as frequently as you would like. But you got to be honest here, and you got to be reasonable. If you give the judge an answer that is not credible, it's really hard for me to come back up and ask the question again, hoping that you'll give a different answer. Because even if you do give a different, better answer, now it kind of looks like, well, which one is it? You know, he said this time, and then he said this. Which one is it? Just be reasonable and honest in your answers. I will usually give a pretend question. You know, pretend that you have a friend, and this friend knows about a job, and they tell you about it, and then I'll describe a job, and I'll give you pretty good details on what that job is. It'll usually be like a telemarketer job, but I'll say you don't have to stand for very long, and you don't have to do much thinking. You're reading from a script. You're not having to do a lot of thinking on your feet. You're telling whoever's called in to about some product that you're wanting to sell, and they found the ad in the newspaper. And if they're interested in it, you literally just tap a button, and it transfers them to a salesman. And then if they say, well, no, I'm not interested, but thanks for answering my call, and you say, well, thanks for calling, and all this is, the computer keeps up with how many of these you're doing a day. And then I'll ask you, can you do that job? Well, answer me honestly, but expect if you tell me, no, I can't do that job, I'll ask you why not, and I want some specifics. Well, I don't think I could sit for that long, even though it's a sit-down job. I don't get along with other people very well. Talking, to other people or reading from a script is almost impossible for me. I can't concentrate long enough to do this, and blah, blah, blah. So just give me the reason that you couldn't do that. And then what will happen in the hearing is the judge will either cross-examine or he might be the one who's asked these questions, but usually they'll turn it over to me. But after I've asked my questions, the judge might ask you, well, you told Mr. Groves so-and-so, and let me follow up on this. And so they'll ask some questions about that. They'll likely ask what I call the vice questions, which are, do you smoke? Do you drink alcohol to excess? Do you use street drugs? Please, 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 please be honest with that. If you use drugs or you drink, I can almost guarantee you've told your doctor that. The worst thing that you can do in a disability hearing is show up and, nope, I don't drink. Or I see this a lot. It's not as serious a mistake for you, but I see this a lot too, which is, well, do you smoke? No. Well, medical record shows that, 3 months ago you were smoking 2 packs a day. Oh, well, I quit. When did you quit? Last week. Just tell the truth, and if you did really quit last week, that's how you want to answer out of the gate. You don't want to say, no, I don't smoke, because now it seems like you've never been a smoker. I smoked up until I tried to, I'm trying to quit or something like that. Just tell the truth, but don't try to sugarcoat anything. And the same with drug or alcohol use. I can guarantee you, especially in mental health records, it's going to be in there, And if you tell a judge that, I don't do any drugs, and your medical record shows that you're smoking weed, 3 times a week, I can guarantee you again, the judge is not going to find anything you say, anything you have said in the hearing credible, and the chances of a denial are very high. Tell them the truth. Even if the truth is embarrassing, you don't want to talk about that. If you had to go through rehab, either for alcohol or drugs, you just tell them that. If you have a history of it, some of the judges will follow up. Well, okay, you're not using, any methamphetamine right now, but I see that you did have a problem with it in 2023. What happened? Well, I went through a recovery program. That's what you need to do. Don't shy away from these things, because remember, you're not there only to testify. You're there to explain things in the case record that the judge might find disabling. So let's talk about some do's and don'ts, and then I'm going to leave it with you. So do always tell the truth. Do always tell the whole truth. I tell my clients that sometimes the truth can lose your case, but the whole truth will never lose your case. So let me give you an example. The judge says, Miss So-and-so, I'm just wanting to know, are you able to do any household chores? And you, well, what kind of household chores, Your Honor? Oh, well, okay, yeah. Are you able to make your bed? Yeah, I can make my bed. Okay, are you able to prepare simple meals like a sandwich or something like that? Yeah, I could do that. Okay, are you able to go grocery shopping? Yeah, I can grocery shop. What about laundry? Laundry, yeah. If I put my mind to it, I can do it. That sounds like truthful testimony, and there's nothing that I can assail about it being truthful. But was it completely truthful? Because every example that I just gave you, are you able to make your bed? Yeah. Are you able to prepare a simple meal? Yeah. Are you able to go grocery shopping? Yeah. You able to do laundry? Yeah. Okay, well, if that is your answer, and that is as far as it goes, I can guarantee you will lose your case. You just told the judge you can do things that are very similar to what you would do in a job. Let me give you an example of what the whole truth would have looked like. Well, Miss So-and-so, are you able to do any household chores? Well, what kind of household chores, Your Honor? Well, can you make your bed? Yeah, I can make my bed. It takes me 30 minutes where it used to take me 5. Oh, okay. Well, what about preparing a simple meal? Can you make yourself a sandwich or something like that? Yeah. I try that from time to time. Most of the time, I leave it on the counter and find it stale in the afternoon. Oh, okay. Well, what about, are you able to go grocery shopping? Yeah, I go grocery shopping. I don't like being around people, so I go in these places that are open, till midnight, and I go grocery shopping at midnight, and I have to ride in the cart. It's embarrassing, but I can't push a cart. I have to make a list, or I have to have somebody make me a list, because I'm completely lost when I go in the store. Why am I even there? I don't want to be there. Other people, if I see them, even though it's late at night, they make me nervous. Oh, okay. Well, what about, laundry? Able to do laundry? If I really push myself, I can do it. It used to take me 3 hours. It now takes me 3 days. There are more times than not where I've completely forgotten what I was doing, and the laundry is soured in the washing machine because I didn't put it in the dryer, and I have to start all over. That's usually how it goes, Your Honor. Okay, so there's some examples right there, and I hope that you see that one of them was the truth, but it didn't really give the whole truth, and it would not win your case. It would actually lose your case. If you're able to do this, you're able to do that, and you never said anything about limitations. But then my second example I gave the limitations. Yeah, the sandwich becomes stale, the laundry gets soured, shopping is an ordeal. Okay, well, you told the whole truth there. Once again, the truth can lose your hearing, The whole truth will never lose your hearing. So make sure that you tell the whole truth. So those are some do's. Let me give you the big don'ts. Don't exaggerate. Don't say things are going on that the medical records don't show are going on. And we'll go over this in a prep. If I hear you in a prep wanting to go down a path, I know I've got carpal tunnel. I know I've got carpal tunnel, and we're talking about things, and then 10 minutes later you tell me I know I've got carpal tunnel, and I will stop you and I will say, why are you harping on this carpal tunnel? I've read every page of your medical file and I don't see it. Well, I've got it. I know I do. I've got numbness and tingling. Have you talked to a doctor about it? Well, I'm going to. Don't bring that up at a hearing. If you bring it up in a hearing and it's not in the medical records, now the judge thinks that you're putting on a show or that you're making things up. There are certain things that you can or you cannot do in a hearing. Talking about things that have no medical foundation or medical record foundation in the file is one of those things. Don't tell me that you have this problem and you've never seen anybody for it. Or worse, tell me that you have this problem and then you've gone to your provider and said that, yeah, I have that condition, but it's not bothering me now. Okay, why are we even talking about it if it's not bothering you? Because in a hearing, we want to talk about the things that are limiting you. There are certain answers that if you give, I can almost guarantee you we're going to lose your case. For example, if I say, Miss So-and-so, I see that you have rheumatoid arthritis. You have difficulties, using your arms and hands. I see the rheumatoid arthritis is in your wrists and your fingers. You have problems using them? Well, that depends. Depends on what? Well, some days, it's better than others. I didn't ask you if it was better or worse on certain days. I asked you if you have a problem using your arms and hands and fingers, and I need the answer. So one of the don'ts that I'm going to be very firm on here is please, please, please don't tell me things like, well, that depends, or, well, that's hard to say, or, well, some days it's okay, and then some days it's not. Those are horrible answers. They don't tell the judge anything, and if you do it over and over again, and I've had, had far too many clients that have done that. If you do it over and over again, the judge will just shut down. He won't be listening to anything you have to say, really. It sounds like you're avoiding the question if you say, well, that depends, or, well, Mr. Groves, that's hard to say. If I ask you how long you can use your arms and hands because you have rheumatoid arthritis, it's because in the medical records I show that you have rheumatoid arthritis and that you've complained of being able to use your arms and hands. Yes is the answer that I want from you. Do you have a problem? If I'm giving you I want a yes or no. Give me the yes or no. And then I'll probably ask, well, how long can you use your arms and hands before you have to stop because the pain or whatever's going on with the arthritis? And then we'll remember that one rule. You'll give it to me in minutes. So it's important for you to answer my question. If I'm asking a yes or no question, please give me a yes or no answer. Do not go down a rabbit hole. If I'm asking you about, this bipolar disorder that you have, does it interfere with your ability to concentrate? Well, you wouldn't believe how hard it is for me to get along with my children because of it. Where are you going and why are you doing that? I need you to stick with me, answer a yes or no question with yes or no. And if I ask you about this disorder, a bipolar disorder, let's talk about the bipolar disorder. We'll talk about getting along with other people or other kinds of impairments later on. And if you do that over and over again, if you try to deflect, you go someplace else. I'm asking you about bipolar and you want to talk about getting along with your kids. I ask you about rheumatoid arthritis and you start talking about problems with your hip. eventually the judge is just going to be tired of it and they're just going to shut down and not listen. And we need the judge to listen and hear what you're saying. So my last thing I'm going to tell you is, at the end of the day, if I've seen a little bit forceful in this video that we're making, it's only because I've had problems like this. I've lost cases, which were great cases, but my client showed up and seemed to forget why we were there. We're there to talk about your impairments that are supported in the case record, and we're there to talk about symptoms, anecdotal evidence, which is, I was in a store the other day and blah, 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 blah. Unless the judge asks, well, give me an example of problems that you have getting along with others, and then go for it. Answer the question. Or if I ask, because I will sometimes ask for some anecdotal evidence, give me an idea of how in real life that this problem with concentration happens. Well, I love Seinfeld. I've been following the Seinfeld show, for 20 years. I love Seinfeld. I can't make it through an episode now. I can't even concentrate long enough to make it through a 30-minute episode of Seinfeld. That, if I ask you for it, that's what I want. And so the last thing that wraps all this up and ties everything together, you have to trust the process. And whether you like it or not, Social Security is part of that process. The administrative law judge, the ALJ, is part of that process. I, as your representative, am part of that process, and you have to trust the process. What do I mean by that? You want to talk about the problems that you have in the grocery store. You're dying to talk about the problems that you have in the grocery store. And the judge or we just keep asking you questions about standing, walking, lifting, carrying, concentrating. We never ask you questions about problems you have in the grocery store, and you're dying to tell us about it. You got to save it to the end, and you got to trust that what we're asking is what needs to be asked and what you need to answer, so we can get it on the case record and we can have the judge make the decision that he needs to make to allow your case. Trust the process. If I felt that what was going on in the grocery store that you're dying to talk about, that you talked to me about it last week and I told you, please, please, please don't bring that up in front of the judge. It doesn't have any kind of materiality to your case. Why are you dying to tell the judge about problems you had in the grocery store? We will probably have talked about it, but if you do it anyway in a hearing, I can almost guarantee you that it'll go poorly for you, because the judge will think that you're deflecting. The best way around that, the best way for you not to feel that you have to get this on the record or you have to talk about something, is to trust the process. Keeping in mind, as blunt as I can say this, I do not make a dime off your case until I win it. If I spend 20, 25 hours on your case and I don't win it, I get nothing. I have a vested interest to make sure that what needs to go into the record and what testimony needs to be given in a hearing, I have a vested interest to make sure that happens. So you need to trust the process with that. Trust that the ALJ wants to make the best decision he make. Definitely trust that I want your testimony to support disability. So remember these things. The thing we're there to talk about, symptoms, and the one rule, give it to me in minutes. If I ask you how long you can do something, give it to me in minutes. Remember those things and trust the process, and we'll have a great hearing.